That's the reason we've allowed photography and video cameras in the courtroom. And I'm going to ask that the media be respectful and considerate of these very serious proceedings. I do reserve the right, I think you've all received a copy of the order that's in effect, and the court does reserve the right to have people removed if necessary, if there's any reason to do that. So having said that, we are in session, and we'll go on the record. This is the 8th Judicial District Court, County of Taos. Sorry, let's see over here. Cause numbers CR 2018-167, which is entitled The State of New Mexico Plaintiff versus Siraj Ibn Wahaj. The 8th Judicial District Court, cause number CR 2018-168, entitled The State of New Mexico Plaintiff versus Lucas Allen Morton. Cause number CR 2018-169, entitled The State of New Mexico Plaintiff versus Suraj Wahaj. Cause number CR 2018-170, entitled The State of New Mexico Plaintiff versus Jani Laville, defendant. And cause number CR 2018-171, entitled The State of New Mexico Plaintiff versus Subhana Wahaj. Counsel, will you please state your appearances for the record?
Tim Hassan on behalf of the state, member.
No, nobody's on behalf of the state.
And Tom Clark on behalf of Suraj Wahaj.
Good afternoon, Your Honor. Maria Brandmiller on behalf of Ms. Sudra Wahaj.
Good afternoon, Judge Megan Mitsunaga on behalf of Ms. Subhana Wahaj.
Good afternoon, Kelly Malay on behalf of James Lavelle.
Good afternoon, Your Honor. Alex Castich and Gregory Dawkins for Lucas Morton.
All right, good afternoon, everybody. Today we're convened on the state's motion for a pretrial detention order. Is the state ready to proceed, Mr. Hassan?
We are, Your Honor. And, Your Honor, we do need to have a discussion prior to the commencement of the state's motion regarding disclosures. And if you prefer me to approach, I could to the podium or from there.
Please approach. I was going to ask if there were any preliminary matters before we started, so thank you, Mr. Kostic.
And Your Honor, there is another preliminary matter regarding, which has been handed as State's 38, if I may address the board. This is not in the
Hold on for a
solicitation.
second. Let me hear from Mr. Kostic first, then you may address the court, Mr. Clark.
And, I think we're both essentially on the same page, Mr. Clark and I, Your Honor. Of course, the state's motion is pending here. They have, we're in receipt of a witness list, or at least subpoenas, for 3 individuals to testify at this hearing. One of those being, I believe, the sheriff, Jerry Hogarth, one being the under sheriff, and a third being a special agent with the FBI. The issue that I see, Your Honor, is that pursuant, of course, to 409, the state is absolutely required to make disclosure of not only exhibits, but all the currently in their possession. And that goes as well for law enforcement, including Taos County Sheriff and the FBI. Now, the issue is that we are in receipt of almost no what would be characterized as lapel videos from this investigation. We are also not in receipt of, and has not been provided, is a tape-recorded interview with one or more of the children that was conducted by FBI personnel. Actually, the witness that is subpoenaed here today. And so the rule is very clear that those items were required to be provided, and we really do not have a fair opportunity under Rule 409 to cross-examine these witnesses without these disclosures that surely exist and surely are in the possession of the state. So that is one issue that we need to take up, and I think that Mr. Clark has a related issue.
Mr. Clark?
Your Honor, on behalf of my client, I'd like to address what's just been handed to me, identified as State's 38. Several handwritten pages from, it looks like a notebook. I can only assume the states had this in their possession based on some news reporting, and to dump this on me and my co-counsel at this 11th hour flies in the face of due process. I suspect what the state is going to do is rely on this to prove our dangerousness of all the defendants and require their continued detention. To dump this on me before a trial starts with this magnitude, with this much media coverage, I think it's somewhat shocking. Now, the handwritten pages beg the question: where did this come from? Whose handwriting is this? What's this all about? Is this a teaching manual or recitations from a teaching manual, or is it in fact teaching material? I don't know. There's no reference in any of this except handwritten pages. And so there's no way to know where this came from, and it's awfully easy to take things out of context when you're making allegations of this sort. And so I have some huge problems, number one, with the admissibility of this document, which is States 38. But the bigger question comes, or the bigger question that's raised is, how long have they had this, and why was this turned over in the mountain of discovery that I have received? There's no reason this should not have been turned over right away with everything else.
All right. Mr. Hassan, do you want to respond to that?
Yes, Your Honor, this is an extraordinary case with, as the court will see, some extraordinary facts. The district attorney's office first became involved in the ongoing procedures leading to this hearing on Thursday, August 2nd, when we reviewed the first several search warrants. Since that time, we've been working ceaselessly to process the events that have taken place and the evidence that has been produced. We have made every effort to be as fair as possible and convey the evidence to all the attorneys as soon as we possibly could. As the court probably knows, only one of these 5 defendants actually had counsel that they knew of, which was Mr. Kostic, until the public defender's office was able to arrange for attorneys from other places to represent them. And so therefore, I think most of them were unable to get the greater part of the evidence disclosed to them on thumb drive until this morning. But we had it available to them on Friday. As for Mr.
You're
Kostic,
referring to the lapel videos and the tape-recorded interviews?
that's correct, Your Honor. With the exception of the FBI interviews that Mr. Kostic mentioned.
Okay. So the lapel videos, but not the interviews with the FBI and one or more of the children?
To my knowledge, those lapel videos have been disclosed. Let me put it this way, and that's because that's where I'm going in the rule, but everything that the district attorney's office has received by way of videos and photographs, etc., I believe has been disclosed on the thumb drives. I haven't looked at them myself, but that is my understanding. But the discovery aspect of Rule 5409, to correct Mr. Kostic, actually requires that the prosecution turn over everything in the possession of the prosecutor. And I think that language was carefully used by the Supreme Court in issuing this rule. There's a lot of evidence in this case, Your Honor. It's being processed as fast as we can do it, but it's possible that some of that simply can't be made available on the short timeline that the Supreme Court has imposed for these hearings under Rule 5409. So we've made every effort to be as fair and to disclose everything we possibly can. It is pursuant to that effort to be as fair as possible, Your Honor, that we just passed out Exhibit 38, which was handed to me approximately 25 minutes ago. And that's because I guess it was just processed by those who are continuing to process the evidence, to catalog it and photograph it. This Exhibit 38 refers to a notebook apparently that was taken into evidence, and was just this morning photographed, because that's when the officers are getting to it. So even though I haven't read it, in an attempt to be really fair to the defense, we've distributed it to them.
And if I could respond briefly, Your Honor. The problem here is this, discovery by a disc here, as we enter the courtroom today. I have personally reviewed that thumb drive that was distributed on Friday, as has my investigator. Neither of us see that there is anything other than what are characterized as 2 safe room interviews with children and 1 2-minute video that was from Sheriff Hogan. There are absolutely, and I know that there were many personnel involved in this investigation. At this point, no lapel videos from them, also no interview from the FBI.
All right, well, Mr. Costa, you do know that these are very expedited proceedings, and so what would your remedy be? What would you propose as a remedy for these supposed violations that you're
Well,
claiming?
and you know, I think that that's got to enter into the calculus of the state when they decide which cases they're going to file for pretrial detention. Now, if they are not in a position to give the defendants fairness, to give them due process, to give them, to make that rule effective, then maybe they should think of another plan. They not only had, they had essentially 3 days previous to this motion being filed in which to work on these disclosures and this evidence. They delayed filing, as you remember, Judge, they dismissed this matter after it had been pending in the magistrate court for 3 days, then refiled in the district court along with this motion for pretrial detention. So they have had plenty of lead time in order to give us the disclosures so that we have
All right,
a fair opportunity to cross-examine these witnesses,
All right.
not right as we're walking in for a hearing.
all right, thank you, Mr. Costa. Yes, Mr. Clark.
Your Honor, my concern is much more practical. And I, upon information, believe at least the sheriff's department's had this document for, since the very beginning.
Well, I don't know that. And I don't know if Mr. Hassan knows that. Mr. Hassan, you said you received that today, just as you came in the courtroom or something, or?
Downstairs, just before coming up here.
And where was it received? How was it received?
It was taken as part of the evidence seized pursuant to the August 6th search warrant, I believe, August 6th.
The search warrant, oh, okay, so that's 7 days ago. And in whose custody was it in?
It was initially in the sheriff's custody, and I believe that the sheriff is being assisted by, I can ask the sheriff this when he testifies. I believe the Department of Homeland Security is assisting the sheriff's office in the cataloging of evidence. But as I said, there are a lot of items there. There have been search warrants executed since the August 6th search warrant. And of course, in that period of time, there were also 11 children that were taken into CYFD custody and have been interviewed for their safety, as is customary. But also out of those interviews has come some evidence that will be used in these cases by the state. But of course, we learn about it, Your Honor, as this evidence develops, and it's simply continuing to develop in an unusual way. So, the facts, Your Honor, and the evidence are frankly shocking and alarming, but I don't think the state realistically is faced with the choice in some situations of, well, we'll wait until we have all the evidence organized. The rule 5409 is intended to reflect the new constitutional amendment, which is about safety of the community and safety of individuals in the community. And so that's why it's expedited. So I think the state has a duty where it sees the need to ask the court for pretrial detention. And of course, if the defendants discover new evidence later, they can ask the court to revisit the question.
Thank you. So I'm not sure what remedy was being sought, but at this time, I'm going to let the hearing is going to go forward. And I think under the rule, if something is proffered during the course of the hearing that you believe is improper, of course, it is your right and duty to object. And my duty to determine whether or not that objection is going to be sustained. But and you do have the right, if there was a pretrial detention order entered today, to bring that up again at some later date. So, having said that, Mr. Hassan, are you ready to call your first witness, or do you want to make an opening statement?
Here's how the state would like to proceed, Your Honor. First, Mr. Lovelace is going to make an opening statement to the court. The evidence is kind of unusually complicated for this kind of a hearing. After he does that, Your Honor, the state has made a proffer. There are a number of documents which are bound and which have been distributed both to the court and to counsel for each of the defendants. So after the opening statement, I want to outline those documents, discuss those documents with the court, and then having done that, the state wants to call 3 witnesses, and then that will be the sum of our presentation. So Mr. Lovelace will make an opening statement.
Your Honor, another brief matter before we begin. I mean, what I'll ask for is, you had raised the issue of remedy. What I would ask for is actually for the testimony of Special Agent Taylor to be expressed today, because we do not have, again, a fair opportunity to confront him, cross-examine him without a recording, without the ability to review the recording that he did of this interview with one of the children of the case. And so, I mean, that would be where the thrust, I would imagine, of his testimony would come from today. And so I don't think it's necessarily fair for him to be able to testify and us not have an effective opportunity to cross-examine.
I'm going to deny that, because I don't believe that the purpose of this hearing is to determine whether there are any conditions that could protect the safety of the community, any conditions of release. That is the purpose of this hearing. It is not a determination of guilt or innocence. It's not a determination. And these are expedited proceedings. It's difficult to get everything together. I understand your concern about it, Mr. Kosich, I really do, but we're gonna go forward now. And so, Mr. Lovelace, will you go ahead and make your opening statement?